This is going to be a basic CLE on the Kansas Sentencing Guidelines Act, and we are going to focus on the journal entry. So we're going to start off with an overview of our agency at the Sentencing Commission and also going into some of these journal entry topics that are questions we get asked about and issues that we see quite a bit. The first is going to be criminal history scoring. This is the big one, so we'll spend a lot of time on that, as well as primary crime determination when you have a multiple conviction case. And then I'll go over with Jessica some current sentencing issues that we are seeing and also including a few of the legislative updates that you'll be seeing in July. Lastly, we'll have some time for question and answer. If you would like to chat, do the chat function or the Q&A for any questions you have, and we will try to get to that in the last 10 minutes. Here is a list of our current members at the commission. Chances are you recognize at least one or two of those names on there. You can tell we are made up of public members, judges, bids attorneys, prosecutors like Jessica, as well as we have a representative from OJA, the Kansas Prisoner Review Board, etc. So we have a pretty good diverse group. Part of our mission as an agency is to make sure that we are aligning felony sentencing policies with correctional resources. That means we work with KDOC, we look at prison bed impacts, and we also maintain the sentencing guidelines system. We administer the Senate Bill 123 substance abuse programs, which we'll have a few updates for you at the end of the webinar. And you can see on here one of our other objectives is to provide education to stakeholders like you all. So we try to put on a training at least once a quarter. If you would like to be placed on our notification list, you can sign up on our website. So I hinted at these a little bit in the agency mission, but this is what our agency really does. So during the legislative session, we complete what are called prison bed space impacts. What that is anytime there's a bill that could affect criminal sentencing, our agency completes an impact statement that has a brief overview or description of the bill. And then we talk about the fiscal impact. So how many prison beds will we need if this bill passes, or how many prison beds will this save? We are the State Statistical Analysis Center, so part of that is maintaining a database of all of the sentencing journal entries, PSIs, revocation journal entries, and that's a lot. What most of you have hopefully attended a training on our case app. This is mandatory in 2026, so July 1 is when attorneys should be for sure using it. And this is our electronic journal entry system. If you have not gotten signed up, please send me an email and I can get you in contact with Peyton Fenwick, who is our research analyst and who is covering that. We also provide annual prison bed population and inmate classification projections for KDOC. And lastly, we run the Senate Bill 123 substance abuse treatment programs. So that includes Senate Bill 123, Senate Bill 123 Plus, as well as RAFT.
Okay, Francis, thanks for going over the general overview of the Kansas Sentencing Commission. One of the things that I am excited about doing is that as the gatekeepers and the guardians, we like to say, for the sentencing guidelines, we have the unique responsibility to ensure that what we are doing provides equity and is predictable and efficient. And one of the reasons we have that database center and those statistics is to try to see what is happening across the state and how we can recommend policies and changes to the guidelines that might be better received and or utilized. As an attorney, I know all of us probably use those guidelines in different ways. You might have felt stuck in a box someplace, or you felt like the box that you're in, and we'll go through the box, is not necessarily the one that your client deserves or that you as a prosecutor believe is appropriate. And so we have departures and other things to do. But overall, the importance of it is that we're trying to establish equity for the type of crime in a typical type case. But we all recognize that there's going to be atypical type instances where we might want to do something different. And that's where we're utilizing those other departures in those cases. Overall, when I talk to either victims or you might be talking to your clients, the good thing, the nice thing about this is Kansas is a determinate sentencing state. And what that means that is in Kansas, a client and or a victim should know what the sentence is, at least a range of it, when a plea happens. And so unlike other states where the judge has full discretion within decades sometimes of sentencing for an offense, we have that determinate sentencing box based on criminal history and the severity level that really holds the judge and ties the judge's hand a little bit to what they can sentence an offender to. And so I think that at least allows us to have realistic conversations about what a defendant is facing, what a victim can expect, so that they understand. That doesn't always mean that either side agrees, right? A defendant might not think that that's the right amount of time for what they committed, and a victim might think that that's not the right amount of time for what happened to them. But it does provide that clarity. And so I am very supportive of the sentencing guidelines and that determinate sentencing process, because I believe it does allow us all to at least know what we're facing as we go through that. So one of the things when Francis and I started to talk about this CLE was really kind of remembering what the basics were. This really is focusing in on that purple part of this criminal justice system flowchart. So the conviction part of it, and then the sentencing for felonies. There is a lot that happens before that. So what it was charged as, what it was investigated as, what you went to trial on, all of that's going to happen before you get to this journal entry position. And then what happens after, we're hopefully going to reflect in a journal entry, whether it be the sentencing journal entry or a probation violation journal entry for the orange and the yellow part of it as it works through the system. But really we're focusing on what was the conviction and what is the sentence that's imposed by the court, and being able to properly account for that on the journal entry itself. Francis mentioned that we're going to the case app beginning July 1st, and this is not a CLE on utilizing Domo and the case app, although we have some of those, I think, posted to the website, and I encourage all of you to look through that. This is really about when you get that PSI and you're trying to score that, or you're trying to talk with your client before you get that PSI about what to be expected. Considerations that you should have in primaries and consecutives and all the things that are going into determining where they're placed on that grid. So the grid, as Francis was introducing our CLE today, I went and pulled out a bunch of my grids. So a lot of you might have this type of grid that has both the non-drug grid and the drug grid on the same chart or handout. The sentencing guidelines have these available on their website. The one that Francis has put up in front of us today is this white, greenish, and blue one. And then for mine on the flip side is the drug grid. But one of the things I always talk about with new prosecutors when they come to our office, and both coming from the federal side and other jurisdictions, it's really important for you to understand what this grid tells us. Most of us know this, but because we're doing an introductory level CLE on this, I really want to spend a few minutes going over it. So that red box at the top, that is your criminal history score. And so that generally is determined through the PSI. Most of us attorneys are control freaks, so we really like to know what that's going to look like before we get to the PSI. And so some of the things we'll go through today will help you determine that. But looking back at criminal adjudications and convictions, as well as diversions, will help you understand that. And so we're going to start over on our right-hand side at an I. That's going to be one misdemeanor conviction or no criminal record. And if that is the client or the offender's criminal history, those are the boxes that are going to be determinant for your client based on the offense that they committed. As we walk across that towards the left, we're going to get higher criminal history. So H is going to be 2 misdemeanors or more. If you just have misdemeanors, the highest you'll get is an H. And so you don't get to that G box until you are a non-person felony. And so that's really the difference. HIs are going to be misdemeanors or no convictions. G is going to be your first felony. F is going to be 2 non-person felonies. So when Francis talks about scoring in a few minutes and how those might convert from out of state, that is something to pay attention to because that's usually where people get caught on some of those. E is going to be 3+ non-person felonies, so 3 or more. And then D is where we get to our 1-person felony. If you have non-person felonies and misdemeanors, but 1-person felony, you start at the D box. You don't get to start down below. It's the highest of what you have. And so one of the things I wanted to point out on our D-person felony and something I've seen catch even me in some of these cases is as we're looking through to try to predict what that criminal history score is to inform our negotiations, remember that 3-person misdemeanors aggregate to a person felony. And so that is one of the sentencing rules we wanted to make sure we highlighted in the sentencing grid. And that is outlined in the sentencing guidelines book, which I always carry with me. I think the new one's coming out in a month or two. It's available on the website. But aggregating of juvenile offenses, which Francis will talk about how those are impacted later, but also person misdemeanors can be one that catches some of us off guard. So if you've got 3-person misdemeanors or a person felony, you're going to be in that D box. Person felony and a non-person felony will be the C box. And then 2-person felonies are B, 3-person or more felonies are going to be your A box. I want to go over severity levels next. So over on the left-hand side in that yellow circle is our severity level. Starting at the top is our severity level 1, and then it goes all the way down to our severity level 10. We have very few crimes that are severity level 10, but those are our lower level offenses. So as you're looking at that grid, you have to look at what is the level of the conviction of the crime. So if it's a level 3 crime that we're looking at, then that's the level of the grid that you're going to look at. You're going to marry that or meet that with whatever number comes down on your criminal history score for the box that your client's going to be in for that crime itself. And so you marry out the level 1 through 10 with the criminal history score, and that's how you figure out what they're subject to. Inside each box is a mitigating, a standard, and an aggravating number. So sometimes we call that low box, mid box, and high box. I think each jurisdiction kind of talks about it differently. The court does have discretion within that box. Sometimes we have plea agreements that will agree to both recommend a standard number. Sometimes it's open where you can ask for the low box or the mitigating number, and the state can ask for the aggravated number. Sometimes you just say plead to the crime and we're open to argue anywhere within the box. And that's what we're talking about, the low, the mid, or the high. And that is all the discretion, unless there's a departure, that the judge has. The last thing I want to talk about on this grid itself is the difference between the green, the blue, and the white. So the white is presumptive imprisonment. If you fall, your client falls within that white box, then they're going to be presumed imprisonment, and the court has to send them to prison unless there is a departure, substantial and compelling reasons to dispositionally depart. Disposition means where they're going to serve the time. If you fall within the green box, you're presumptive probation. That means the court must sentence you probation unless there has been a departure motion filed to find a different disposition for you to prison. The blue box is what we call border boxes. And blue boxes say that the court, it's presumed prison, but the court can sentence you to probation if they find certain factors exist. Community interests are served. There's a rehabilitation program that would serve the interest of the defendant. There's just specific factors listed again in our sentencing guidelines book that the court must determine in order to send somebody to probation. It's a lower standard than the substantial and compelling reasons needed for a departure motion, which we'll go into a little bit. The drug grid is set up exactly the same way, even though we don't have that. Well, we do. It's the next slide. Thank you, Francis. We've got the severity levels across the top or the bottom side, the criminal history score across the top. You marry them based on where the offender is. And then we've got our border boxes and our presumptive probation boxes. The box there at the bottom is our drug distribution or possession with intent to distribute grid. I don't know how many of you have looked at the drug statutes where we're trying to figure out what level the offense is. Most of those are all determined on the amount of the substance or the drug. And so this is a nice little box where it kind of gives us a cheat sheet on what type of drug is it, how much is it. This is where the severity level is for that, so that we understand where we place it on the drug grid itself.
We will be doing a comprehensive review of the guidelines. I wanted to mention that we secured funding to start that process. So you might be contacted, or you might hear about different ideas, or if you have any ideas, let us know. Now is the time for really reevaluating both of these grids moving forward. They haven't been changed substantially for over the 30 years that they've been in existence. So I wanted to throw that out there and let you all know what is coming soon.
Yes, Francis, that's a very good point. I get to be a member of that subcommittee that's starting to look at that, revising the sentencing guidelines. Remember that when they were enacted in the mid-90s, they put numbers in a box, and then crimes were severity levels. And we try to account for the right equitable sentence for that crime. But since then, crimes have been added, crimes have been amended up and down, criminal history comes into play as well. And so we have seen some disproportionate sentencing. We see a lot of departures on certain levels, certain types of crimes. And so it's going to be a great opportunity for us to really take an in-depth look at our sentencing guidelines and potentially make recommendations as to severity levels, as to whether we should be using the same criminal history scoring, whether we should still have the same numbers in those boxes as an individual is sentenced. So look forward to that, and I hope all of you will participate in that process. I did mention departing from the grid. And so when we talk about departing from the grid, we're talking about that departure motion, whether filed by the state or the defendant, that makes the judge, allows the judge to have the flexibility to sentence them to a different sentence. And I mentioned dispositional departures. We also have durational departures. So dispositional departures, as I mentioned, are whether it's a prison or probation. Durational is the amount of time that it is. So if it's supposed to be 36 months, a motion for upward durational would be for a higher amount. A motion for downward durational would be for a lower amount. The sentencing guidelines allow for mitigating factors for the court to find substantial and compelling reasons for the departure. These factors, remember, is a non-exclusive list. So the court does get to review the factors set forth by either side on whether there should be a departure. And they're all enumerated here. The victim was an aggressor or participant, does not apply to sexually violent crimes. The offender played a minor or passive role. This is not sufficient for self-defense. The offender, because of physical or mental impairment, lacked capacity for judgment. The voluntary use of intoxicants, drugs, or alcohol does not fall within the purview of that. The defendant or the defendant's children suffered from a pattern of abuse, and the offense is a response to that abuse. The degree or harm or loss attributed, it was less than significantly typical. And then the offender committed such crime as a result of an injury, including major depressive disorder, polytrauma, post-traumatic stress disorder, or traumatic brain injury, conducted to service in a combat zone. And so that's a veteran's mitigating factor. Additional mitigating factors are in 216815E that may be considered. The court's evaluation of the significance and usefulness of the defendant's assistance in prosecution, truthfulness, completeness, and reliability of information provided, nature and extent of the defendant's assistance, any injury suffered or danger or risk of injury to the defendant or the defendant's family resulting from such assistance, and then timeliness of the defendant's assistance. This is for cooperating defendants to utilize when setting it forth. However, remember, this is not an exclusive list. So an offender can plead another mitigating factor. There is a lot of case law, and if you look through the statute, supporting mitigating factors and what is and is not substantial and compelling. So take a look at that. When we're talking about mitigation, we're usually talking about a lesser sentence. And so there doesn't need to be a jury finding for a lesser sentence, but we're going to talk about that differently when we talk about aggravators. And here we go. So an aggravating factor would be a reason why an offender should serve a sentence that's longer than what's in that box. So either durational, so the time, or dispositional, prison as opposed to probation. And so this again is a non-exclusive list of aggravating factors that can be used. The court must find that there's substantial and compelling reasons to depart based on one or a coupled, more than one of these factors. The first is that the victim was particularly vulnerable due to age, infirmity, or physical mental capacity, and that was known to the defendant. The defendant's conduct during the commission of the current offense manifested extreme brutality, not normally present, so it can't be what we typically would see. It must be more heinous, atrocious, and cruel. The offense was motivated by the defendant's belief or perception, entirely or in part, of the race, color, religion, ethnicity, national origin, or sexual orientation of the victim, whether or not the defendant's belief or perception was correct. It doesn't matter if you're doing the hate crime and you believe that that's the right thing, it's still a hate crime. The offense involved a fiduciary relationship that existed between the defendant and the victim. The defendant, 18 or more years of age, employed, hired, used, persuaded, induced, enticed, or coerced any individual under 16 years of age to assist in the crime. The defendant's current crime is extreme sexual violence, and the defendant is a predatory sex offender. The defendant was incarcerated at the time of the crime, or the crime involved 2 or more participants in the criminal conduct, and the defendant played a major role in the crime. In addition, as we previously mentioned, there are other aggravating factors that apply to drug felonies committed on or after July 1st. And those are also reasons the court can find substantial and compelling reasons to depart in drug grid crimes. So we've been talking about the grid itself, right? Whether it be the drug grid or the non-grid. Francis, go back for me real quick on that. I mentioned that you don't have to have any additional findings on mitigating factors. One of the things that I like to talk about is that when we're doing upward durational departures, that requires a finding by the finder of fact beyond a reasonable doubt. And so if there is a motion for an upward durational departure, so that they're going to be sentenced to longer than what would be presumed, the defendant has a right to a jury trial on that factor, and you must submit that factor to the finder of fact, whether that be the court at a bench trial or the jury at a jury trial, to make that determination. If an offender is pleading to an upward durational departure, they have to waive their right to jury trial on that factor. and essentially also plead to the factor as well as the offense that you're talking about and waiving their right to the finding as well. So those are a couple of points to point out on our departure motions, especially when it comes to upward durational departures. Criminal history classification. So can the prior conviction be used? I think, Francis, this is where you get to take over.
Yep, thanks, Jessica. As I mentioned earlier, one of the areas we get a lot of questions on is criminal history classification. So we figured if we're going to do a journal entry training, we have to include the criminal history worksheet. So what you will see here, I just put little boxes for the first thing you're going to be looking at when you're trying to decide if a prior offense can be counted towards an offender's criminal history is first you have to determine if it can even be used. Then you need to look at if the offense should be a felony or a misdemeanor. Lastly, a person or non-person if you decide you can use it. I made this little chart. It is just based off of 216811 E2. If you are looking at an out of jurisdiction offense to see if you can include it in your criminal history, you will first look at whether the offense is a felony or a misdemeanor in that other convicting jurisdiction. If it's a felony in the other jurisdiction, it will be a felony in Kansas. If it is a misdemeanor in the convicting jurisdiction, you're going to want to look at the comparable Kansas misdemeanor that is in effect the date the current crime of conviction is committed. I bolded that because in all of these analysis for whether it's misdemeanor or felony, you're going to be looking at the current crime of conviction committed for the date. So again, if it's a misdemeanor, you're going to either score it as an A, B, or C in Kansas, if that's the comparable crime. If the comparable crime in Kansas is a felony, then it will automatically be a Class A misdemeanor. If you can't find any comparable offense in Kansas, you should not be using that in your criminal history. Lastly, if your offense from the other jurisdiction is not classified as a misdemeanor or a felony, so think of maybe a military court as an example, you're going to refer to the comparable Kansas offense in effect the date of the current crime of conviction took place to either classify as a felony or misdemeanor. Again, if there's no comparable Kansas offense, do not use that. So misdemeanors, I wanted to touch on this because like Jessica said, we'll go over the misdemeanor rules for conversions. Misdemeanors, you're still going to be using that Wetridge test. And that was back from 2018. So those of you who have been practicing a little while, you remember we had a few different cases come out that talked about whether a crime would be comparable to another crime. Wetridge was the last one, and that's what you will be using for misdemeanors. So again, you look at whether the elements of the out-of-state crime are identical or narrower than the elements of the Kansas crime. And here are the rules. These are in the DRM. I think Jessica mentioned that. The first one you're going to look at is if you have Class A person misdemeanors and Class B person misdemeanors, those will convert to person felonies at a rate of 3-to-1. And we put an example below that. The assault rule is a little different because you have a time period restriction. So what the assault rule says is that every 3 prior adult convictions or juvenile adjudications of misdemeanor assault, as defined by statute, that occurred within a period of 3 years, commencing immediately prior to the date of conviction for the current crime, those are going to count as a person felony. So keep that in mind. I also want to mention, I don't have the case cited here, but the offender does have a right to counsel in these misdemeanors. So if you are getting misdemeanors from a municipal court, for example, there should either be a waiver of counsel or the defendant should have had counsel. So I know a lot of municipalities will have a waiver of counsel now, and that should be included. So as I mentioned, we got rid of the comparable case law, I guess, for person or non-person felonies. What we got instead now, what we have instead is 216811 E3B. These are the factors or the elements you'll be looking at. If the elements of the out-of-state offense have any of the following, then you will treat the prior offense like a person felony in Kansas. So I'm not going to go over each of them, but they are listed out here, and you will have a copy. I will say the trickiest that we've seen so far is D, the presence of a person other than the defendant, a charged accomplice, or another person with whom the defendant is engaged in the sale, distribution, or transfer of a controlled substance or non-controlled substance. We've gotten the most questions, and there's not a ton of case law on it yet, so that I think has been the most gray area out of all of these elements. Juvenile adjudications, I wanted to cover this because it is an area that we do receive a lot of questions on. So the big thing is that juvenile adjudications are not the same thing as adult convictions, and the Kansas courts have been very clear about that. I like to use State v. Crawford. It's kind of an older case, but it's a Court of Appeals case from 2008. And what happened here was the defendant had been serving probation on a juvenile adjudication. At the time that he was on juvenile probation, he committed a felony as an adult. So the judge in his adult case, when he was sentenced, applied Rule 9 to run the cases consecutive to each other. The Court of Appeals said, no, you cannot do this because the juvenile adjudications are not listed specifically in Special Rule 9. So again, the Court of Appeals said the legislature would have included specific language listing juvenile adjudications. So because they didn't include that language, they meant to exclude juvenile adjudications. So when you are looking at special rules, make sure you look at the specific statute. If it does not specifically state juvenile adjudications or the word adjudications, we are telling practitioners that you cannot use it unless it's specifically stated that way. The other part of special rules that I wanted to mention here is we've gotten some questions when you have habitual offenses. So say Special Rule 26, if you can use out-of-state convictions for that. And luckily, we just had a case come down, even though it is an unpublished case, it confirms what we have thought the last few years at the commission, where if a special rule states only the Kansas statute number, you are not going to be able to use out-of-state offenses. So with Special Rule 26, the statute specifically says prior convictions of 215706. So you cannot use out-of-state convictions to apply Special Rule 26. Here is the juvenile gap provision, and this provision I wanted to mention does not mention the person's age at all. What's important here is that you have a gap of time where new offenses were not committed. So here's a little chart. If the defendant had a current crime of conviction that is at least 5 years after the date of the prior adjudication, they have no new adjudications during the 5-year period, and the prior adjudication has to be a non-drug severity level 5 through 10, drug felony, non-grid felony, or misdemeanor, then you're not going to score that prior adjudication. Now, there have been some questions about whether traffic offenses count, and I would be curious what you all think, or if you have any experience with that, because we have seen a few cases come down on that. So juvenile decay, this is the statute that requires the defendant to be the age of 25. So once they reach the age of 25, they don't have to have a gap. So there's not this time requirement where they can't commit any new adjudications. So this only applies to juvenile adjudications. They will decay if the current crime of conviction is committed after the offender reaches the age of 25. However, the juvenile adjudication has to be something that was a non-drug severity level 5 through 10 felony, non-grid felony, or any drug felony if committed by an adult, or if it would have been a misdemeanor if committed by an adult. Criminal threat. This is finally working itself out, I think. Our agency's belief now is that you have to have an intentional criminal threat as a prior, otherwise you cannot use it. So we used to be able to find someone guilty of criminal threat either recklessly or intentionally. State v. Boker overruled that reckless disregard part of the statute because it was too broad. Counterman v. Colorado was a U.S. Supreme Court case that was decided after that. The victim in that case was a musician, and Counterman basically stalked her. He would send her messages even though they never met on social media. Some of the messages indicated he might know where she was. So the U.S. Supreme Court in that case said essentially that reckless is enough. So then we had a lot of questions in Kansas of whether Boker was overruled by Counterman. The Supreme Court, however, last year in 2025, in State v. Smith said it does not matter. Counterman doesn't really affect our analysis because in Kansas statute, it says that if a prior conviction arose under a statute that has since been determined unconstitutional by an appellate court, it cannot be counted in criminal history score. So again, they did not really take into account Counterman, but looked at Kansas statutes and said that because reckless criminal threat was once ruled to be unconstitutional, it cannot be used. Okay, if a prior criminal history has changed, so think about failure to register, you're going to be using State v. Keel. So you're going to be looking at the law applicable at the time of the current crime of conviction. State v. Terrell was a case that I think helped to determine how broad or narrow Keel was. This was a current conviction of aggravated escape. The offender had a prior conviction of failure to register. So he was registering for rape, which made it a person felony, his failure to register. The district court classified his failure to register as a person felony under Keel because originally it was a non-person, but then it was changed to a person felony when he committed his current crime, which was aggravated escape. So what Terrell told us was that under the Sentencing Guidelines Act, all prior convictions, whether they're out-of-state pre-guidelines or amended post-guidelines, are to be classified as person or non-person as of the time the new crime is committed.
Okay, so what is our primary crime? When we're going through the sentencing guidelines, we know for the journal entry purposes, the first offense, the base offense, what you're going to put there in that first sentencing provision is going to be our primary crime. But sometimes our primary crime might not be our highest severity level. So we really have to look and see. And as great as some of the court services officers do in doing our journal entries or our PSIs, most of the time they're going count 1, count 2, count 3, count 4, count 5, not primary crime, non-primary crime. So I think it's important when you're looking at what the determinant sentences are, which one's going to be scored. Remember, only our primary crime gets that criminal history score. Our non-primary crime is going to get an I number. So you really need to know which one's going to be that primary crime. When there's more than one conviction, the sentencing court must determine that base. And my belief is the prosecutor and the defense counsel usually need to help the court with that. Because sometimes when they're just listing through, they don't focus on what a primary crime is. You're going to look at the crime that has the highest severity level. And then if you don't have the highest severity level, you're going to look at the crime that is presumptive imprisonment over presumptive non-imprisonment. And we have a couple examples of that. What should be listed as a primary crime when there's an off-grid and grid felony in the same case? So what did I just say? I just said usually it's the highest severity level that's your primary crime. But that does not work when we're talking about off-grids, because your off-grid is going to be your life sentence, 25-50 type crime, right? Well, when we're talking about grid sentencing, are we talking about the off-grid crimes? No, we're not. So in order to get a primary crime and to apply your criminal history score, you need a grid offense. So when an off-grid crime is part of a multi-count case, the primary on-grid crime is determined to base the guideline sentence for full criminal history. So your off-grid crime might be your highest severity level, but your on-grid crime is going to be your base sentence. And that is applicable when we're talking about a lot of different things. Additionally, if the sentences are consecutive, the offender shall not begin to serve the on-grid sentence until paroled from the off-grid sentence, and the post-release term is based on the off-grid sentence. So this gets rather confusing, right, when we're putting all this on a journal entry. I'll be honest, I've struggled with it over the years as well. When you're listing your primary crime, it might be a level 5, it might be 36 months. That's what you're going to put first. Then you're going to say consecutive to your off-grid crime, if that's what the court ordered, it's going to be listed second. But actually, when that journal entry is effectuated, when the defendant is serving that time, DOC is going to make them serve the off-grid time before they come back and serve the on-grid time. So your journal entry is almost counterintuitive to what the practice of that application of the order is going to be, because they have to be separate from each other, and because the on-grid can't start until the off-grid is done, because the off-grid, as we know, sometimes doesn't end in 25 years. It might be 32 because of parole decisions, there, so forth and so on. And then the post-release term based on the off-grid sentence. This one always gets me as well. So depending on our severity level, we might have a 24 months post-release supervision period for our on-grid primary crime, but our off-grid is going to be life with the possibility of parole after 25 years. Well, that means they're going to go before the Prisoners Review Board. They're not going to have the post-release time. You're going to note it on the journal entry, but what's going to be controlling is what controls for that off-grid sentence. What is the primary crime when an offender is convicted of crime sentenced on the non-drug and the drug grid? So we're looking at both non-drug and drug grid, so we're going back and forth between the two. What you're going to do is you're going to look at the sentence that is the highest length of sentence and or the highest prison sentence, okay? So if you have a lower severity level on the non-grid sentence that has a presumptive prison count, but a higher level has presumptive probation, then you're going to go with whichever has the higher imprisonment as a prior crime. Okay, what is a primary crime when there is a non-grid and a grid crime? We already talked about this. You're going to go with your grid crime, not your non-grid crime. And then what is the primary crime when a special rule applies? We are lucky to have some case law that help us with that, and that's the State v. Kimberline case. So in that case, there was multiple convictions. The court determined that the sentencing court must first apply the special rule to any third or subsequent conviction for possession when determining which the primary crime is. And what they essentially said is you apply your special rule, and if your special rule gives you a presumptive imprisonment on one of those offenses, then that offense is what has to be the primary crime, not the higher length of sentence. And so they applied, in this case, Rule 26 to find that one of the third or subsequent felony drug possessions was presumptive imprisonment. That became the primary crime, even though the offender was convicted of a non-drug crime that had a presumptive probation sentence. The two drug crimes with the presumptive imprisonment sentences were higher, and so one of them was the primary crime in the case. I do not see, Francis, did we want to pop in real quick and do our thinking about the same thing? So for whatever reason, I call this the double-double rule. I don't know if some of you do, maybe it's just because I'm old school, but it is the double rule. And what that means is that when we have consecutive sentences, the total controlling sentence cannot exceed double your primary crime sentence, okay? So if your primary crime sentence is 12 months, and then you have two other counts that are consecutive to that, and they're both 12 months as well, you go ahead and list the sentences for those in their individual counts. So 12 months, 12 months, 12 months. But your total controlling sentence when you do your sentence recap has to be 24 months because it cannot exceed the primary crime, double the primary crime. This really can be important when you're doing multiple count case negotiations or you're working with a client who's facing multiple counts. What is their maximum exposure? So even though you're really going to want to know what is my primary count, what's the max that I can get on that to see how much even the court could stack. Because remember, our recommendations with plea agreements are just recommendations. The court can stack even if we've offered or asked for the court to run something concurrent. So the court can stack as many offenses that they want back to back, but the total controlling sentence cannot be more than double the primary base sentence. Okay, what is consolidation? So it really needs to be formal, and there's some recent case law on that as well. So just because we pled two cases on the same day does not mean the cases are consolidated. Because we use prior criminal history to determine how to score our cases, the cases are only consolidated formally. So within the same case, then the counts don't count against each other. But if they're not formally consolidated for trial, then the cases, even if they're pled the same day, and we learned this from Shipley, even though they're pled the same day, the counts from one count can count against the cases in the other count. And so the criminal histories can be used against each other. So if you're pleading a case all in one day, you really need to know, were these consolidated for trial? And if that is the party's expectation, then have the court find a finding of consolidation for purposes of that case, and then plead that case, go through the sentencing on that case as if it's one primary count with the criminal history score and the rest of them don't count against that. Otherwise, you're going to be using those cases against each other for purposes of criminal history, because prior conviction is not prior conviction in time necessarily. I'm going to say that with a caveat. It's a prior conviction at the time of the conviction of the case that you're on for sentencing. So that gets a little sticky when we're talking about multiple case disposition. Okay, Frances, current sentencing issues in Kansas.
Okay, so we have a few. Luckily, I get to cover jail credit. So I will do this quickly because we do have new legislative bill that got passed. So this is how the jail credit statute looked before we had changes. So you can see you were supposed to give a defendant time for any credit for any time he or she spent incarcerated pending the disposition of the defendant's case. So we had Hopkins that came out, and essentially what Hopkins said was that that rule that had been used in the past really didn't make sense. It was unworkable, and the defendant is not limited to time spent solely in custody for the charge for which the defendant was being sentenced. So what we had next was a legislative fix, and we had amendments added. So the amendments after Hopkins are down here, 2A and 2B. So when computing the defendant's sentence, the following shall not be considered: time spent incarcerated. And you can see any time awarded as credit in another case when consecutive sentences are imposed, or any time spent incarcerated in another jurisdiction if no hold had been issued. So Irwin came out after that, and so some duplicate credit was allowed. Because of that, we have more amendments that were passed this year that will be coming July 1, 2026. This is supposed to prevent duplicate credit when you're giving someone jail credit. So the amendment here says, it talks about consecutive sentences. So when they're imposed, days spent in custody that are attributed to, that can be attributed to more than one case shall be credited only once. And what you can see here, I bolded what I think is probably the most important part, is that this is going to apply the provisions to all sentences, whether they are pronounced before, on, or after July 1, 2026. The Oops, sorry about that. So make sure you read that bill and you're aware of it. Let's see. When you are filling out journal entries, you will use, so if you have a range, maybe a sex crime is where we see it a lot, you will use the journal entry where the conduct first started. So it's in Domo, if you've been using KSAP, it was populating to the latest offense, but if you have a crime that's spanning a few years, you should be using, we believe, the first journal entry that would apply. So Domo is getting fixed to do that, and you should see it. If you have an old crime, but it's a probation violation journal entry, it does not matter when the crime occurred, you'll use the current probation violation journal entry. So that one's easy enough. A few things on our Senate Bill 123 programs real quick that I wanted to alert you to is when we are talking about regular Senate Bill 123, Special Rule 26, as most of you know, will trump that. So if an offender is ineligible for Senate Bill 123, they can still be eligible for Senate Bill 123 plus. The change here that I wanted to mention, starting July 1, 2026, is that there are going to be a few special rules that will trump Senate Bill 123 plus. And I put them all out here in case you're not as familiar with them. They're like habitual rules. So Special Rule 27, 29, 47, those are the three I think you'll see the most. Special Rule 30, that's never been funded, but it could be, I guess, an option later. Special Rule 31 and Special Rule 37. So those will all trump Senate Bill 123 plus. I wanted to let you know that starts July 1, and that is will function similar to how Special Rule 26 trumps Senate Bill 123. As far as RAFT, our drug diversion program, just a reminder, this at this time only applies to 215706 and those who fall into 5C through 5I. There's nothing in the case law yet about whether if someone's revoked from RAFT, if they would be eligible for Senate Bill 123. Our agency believes they would be eligible at this time. They would presumably fall into 5C or 5I of the guidelines, which would be mandatory Senate Bill 123. However, just note that the offender would still need to meet the risk needs criteria. And that is all. We have a few minutes for questions. If anybody has questions, I have put our website as well as my email right there if you have any questions. But we do have a few minutes if anyone has any questions. And I'm going to put in the chat box Peyton Fenwick's email. If you need to get a profile for KSAP, you can definitely send her a message and she will help you with that. And our webinar will be posted online. Someone just asked that.
Francis, we have a question. How does the gap provision decay work with the burglary rules in 216811D?
Could you ask us specifically on those? Or you can send us an email because I'm not sure what you mean by that question.
So Patrick, if you could follow up specifically on an email to Francis, she'll make sure you get an answer to that. We have some great staff attorneys there at the Sentencing Commission that can help with that. Any other questions? And do district courts have court services prepare a criminal history prior to conviction?
Yeah, and that is one thing I wanted to mention is the CSOs are looking at criminal history and they are doing that worksheet prior to. And so a lot of those CSOs who are completing the PSIs, they are essentially, they have to know all of this sentencing law. And so make sure that you are really looking at those prior cases because some of the criminal threats and things like that, they are changing all the time. And the CSOs have to keep track of all of these new changes while they're also trying to do the other parts of their job. So they are preparing it ahead of time. I think different jurisdictions are handling issues differently and separately once they come up. Like, for example, I know with criminal threat, we have told the CSOs to mark on the PSI, maybe state v. Boker, or alert the parties they're not sure if a criminal threat is intentional or reckless. But I really think it depends on what jurisdiction you're in, on how much the CSOs are doing.
Yeah, and I've seen across the state, some jurisdictions will allow for pre-plea PSIs, which is what we used to call them. And other jurisdictions say, no, we're not doing that anymore because the court services officers are really busy. And so they're doing the PSIs after the conviction for sentencing as ordered by the court, but their courts are not allowing them to do pre-plea PSIs, which is why I think it's really important for attorneys to also look at those criminal histories and try to have an understanding of it and be able to evaluate it. Also, remember when they do those, as Francis pointed out, they're not attorneys. They do have counsel they can consult with, but they're not attorneys. So they're not going to know the specifics of your case and how those crimes and the criminal history can apply to that. So you kind of have to do your own research on those before you just walk into sentencing. I always look through that list of prior convictions to ensure that it's actually been scored correctly, regardless of whether you're for the state or for the defendant. We had one more question about whether this is going to be posted on the website. And I think Francis said, yes, we're going to post this on the website. So
Yes.
this should be available and the materials should be available. Correct, Francis?
Yes. Yep, the materials will be available, and I will be covering legislative updates at the end of June. So make sure you're signed up for our notifications so you'll get alerted to that. But there are more changes coming.
So there was a question on finding crime statutes for other jurisdictions for criminal history purposes. What I generally do is I try to get the crime of conviction from the criminal history or the journal entry, and then I look it up in Westlaw to see what the elements of it were there, and then I do my analysis back and forth. There's other ways, but I don't know how you do it without getting Westlaw or some other type of system to be able to pull those criminal codes because they're all different.
Yeah, and if you have a specific question on something that's tricky for you on another state, always email us because we're getting asked these questions by people across the state of Kansas. So chances are we've probably been asked a similar question. So feel free to email us if you need any assistance with that. Okay, I'm not seeing any other questions. Thank you everyone for attending, and thank you, Jessica, for presenting with me. I will get this posted, and you can feel free to email us if you have any questions.
Thank you.
Thank you.